You're charged with theft under $2,500 enhanced. That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine.
A theft charge, a mental health defense, and a judge who doesn't tolerate excuses. Today's case starts with what seems like a simple state jail felony, theft under $2,500. But what unfolds inside this courtroom is far more intense. Judge Stephanie Boyd methodically walks the defendant through every right she's giving up: jury trial, confrontation, silence. And what's hanging over her head? Up to 2 years in jail and a $10,000 fine. Deferred adjudication may be on the table, but one wrong answer, one inconsistency, and everything changes. Watch closely, because what begins as routine procedure turns into a powerful examination of accountability.
In 2022 CR 4011, State of Texas versus Talitha Anna Delvis Perales. Can I have parties announced for the record for the state?
Laura Metzel for the state.
For the defense?
Russell Mitchell for the
All right. And are you Miss Perales?
Yes.
All right, defense, I'm showing you what's entitled discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
I have, Judge, and I did.
Court will find that the state is in compliance with discovery. Ms. Perales, I'm showing you what's entitled application for deferred adjudication community supervision. Did you review that document with your attorney? Did you understand it, and did you sign it?
Yes.
Next, I'm showing you what's entitled true bill of indictment. Did you review that document with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Ms. Perales, I'm showing you what's entitled court admonishments. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes.
Did you understand you're charged with theft under $2,500 enhanced? That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes.
If you have a plea bargaining agreement with the state, the court does not have to follow your plea bargaining agreement. If for any reason the court does not follow your plea bargaining agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand by entering this plea bargaining agreement, you were giving up those rights?
Yes.
Did you intend to give up those rights and enter into a plea bargaining agreement in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes.
Counsel, has your client been able to provide you with any defenses?
She has to.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I believe she does.
Do you believe she's currently competent and was legally sane at the time of the offense?
I believe she is competent and was sane.
Ms. Perales, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Has anyone promised you anything other than the plea bargaining agreement? Are you satisfied with the way you've been represented? Are you a U.S. citizen? Court will find that the defendant has knowingly and voluntarily waived a right to jury trial, showing you the plea bargain page. Did you review that with your attorney? Did you understand it? I'm going to need you to speak up.
Yes.
All right.
This is a turning point. The judge has reviewed the evidence and confirmed there is sufficient evidence to find the defendant guilty. That means the case is legally solid. But instead of entering a conviction immediately, she grants deferred adjudication. Now let's break that down. Deferred adjudication is not a dismissal. It's conditional mercy. If she completes the term successfully, there won't be a final conviction on her record. But if she violates even one condition, employment deadlines, drug testing, no contact orders, the judge can immediately adjudicate her guilty and sends her up to 2 years in state jail. So the question becomes, is this a second chance or a high-wire act with no safety net?
All right. According to the plea bargaining agreement, there's to be a $500 fine, and the state recommends deferred adjudication. Did you understand that to be the plea?
Yes.
Defense?
Yes, Judge.
State?
Yes, Your Honor.
Next, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Council, have there been any such motion?
Sorry, Judge.
Have there been any such motion?
No, Judge.
Next, I'm showing you outside the plea bargaining agreement, the state is requesting that your deferred adjudication be for a term of 2 years. There be a TAP evaluation, no contact with HEB number 13 and CAT's theft course. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to the offenses charged in indictment, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
At this time, we offer State's Exhibit 1 and all attachments.
No, Judge.
Ms. Morales, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations.
I found a few places near you.
Your attorney.
I'm sorry, Judge, I didn't quite hear you.
I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it and did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. However, the court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
We'd like to do that today, Judge, if we can.
Anything you wish to say on behalf of your client?
Judge, obviously, we're asking the court to follow the plea bargain. After meeting with Mr. Villas a couple times, I've been doing this a long time, but I think she truly understands the stealing stuff has got to stop. And once she got out on bond, if I can approach, show the court, she's been attending.
Any objections to the court reviewing this?
No, Your Honor.
She's been doing that since she got out on bond. And
Mhm.
she's tells me today that that's really helped her to try to break this pattern of stealing.
All right, anything you wish to say?
No, that I am very sorry, and I am in compliance with the mental health care.
Okay, why were you stealing? I don't understand.
I guess I don't know. I was just doing some crazy things. And now
I mean,
I'm
what you
meditating.
selected, I mean, at least it appears to be health conscious. There's the watermelon bowl. There is the chef's salad. I mean, the lunch meat, people never know what they put in meat these days. A black t-shirt
Well, yeah, I just, I mean.
and biologed products. Those are expensive.
I was homeless at the time, just gonna divorce. I didn't have the money, which is no excuse, but I needed to be on my medication and I was doing some crazy thinking.
So why have you been stealing in the past? And mind you, these questions I ask, it's not designed to embarrass anyone, but I'm trying to figure out what your thought processes are because
I needed to be.
I'm
on
trying
my
to figure out
medication.
what your thought processes are so
Um,
that we won't be back here again.
I wasn't on my medication and I have been needed to be on my medication.
What medication?
Abilify and they have me something for a PTSD.
Do you have any children?
Yes,
What are their ages
30, 22 and 17
and where do they stay?
daughters. Not liking it and she just told me she needs it. I needed to, straighten up her. I was gonna miss out on a lot.
And let me see something here. Why were you late for court today? Why were you late today?
Judge, if I can explain, she wasn't late. She was a bond forfeiture.
No. I called the docket and she was late.
Oh, I don't know.
I got here about 9:10.
That's
Only
late.
because of parking, I mean.
So again, we're back to the question.
There's no-
Here's the thing. Why were you late?
Because of the parking situation. I don't have money, a whole lot of money, so I had to park somewhere or and to walk. Really, there's no excuse for that.
Notice what's happening here. The judge isn't just sentencing. She's dissecting decision-making, living in a car, staying with an adult daughter, no employment, untreated mental health, recent divorce. This isn't just about shoplifting groceries or a t-shirt. The court is evaluating patterns. When a defendant says she wasn't on medication, the judge pushes further. What medication? What diagnosis? What's the plan? That's not humiliation. That's risk assessment. Because deferred adjudication only works if stability exists. And here's the hard question for viewers. If someone struggles with PTSD and bipolar disorder, should the focus be punishment or structured treatment? Or can the court realistically balance both?
All right. So who do you live with?
I'm staying in between my daughter's house and my car,
How old are you?
49.
Here's the thing. Parents really shouldn't be dependent on their children for a place to live. So why are you living in your car and at your daughter's
I
house?
was recently divorced and threw me out.
Okay. So you didn't have plans in place for that?
No, nobody but my daughter.
Well, here's the thing. Your daughter has her own life to live, and I don't think your daughter had plans to have her adult mom living with her.
She doesn't, but she did. I mean, offered me a place to stay, so I took. That's a big enough home, and she was able to help me.
Do you have employment?
No, not right now.
Why not?
Well, because I'm disabled, and they're trying to help me.
What is your disability?
On my mental issues right now.
And what is your diagnosis?
PTSD, bipolar disorder, manic depressive. I have letters from my case managers.
All right. Is there anything else from either side?
No, Judge.
Nothing from the state, Your Honor.
All right. That's going to be a $500 fine that'll be probated, 2 years deferred adjudication, proof of employment or disability within 30 days. You're going to be allowed to live with your daughter if she'll have you for 90 days. At that time, you need to make arrangements to live elsewhere. You understand?
I have a letter saying that I am in that hospital.
So probation, she's only supposed to be with her daughter for 90 days. After that, she needs to have her own place.
Yes, Your Honor.
There's to be no contact with HEB.
We were just doing HEB number 13, Judge. Specifically.
She's going to have to go somewhere else.
They told me a year, but I mean, whatever it takes to do.
All right, there are other stores here in town, I believe.
That's a place else to shop. Not shoplift, but it's a shop.
And I'm going to leave that no contact with HEB, then we'll leave it in place for 1 year. They want you to do the cat's theft class. Here's the thing, don't take what doesn't belong to you. And if you go to a location and somebody asks you to leave, you need to leave. Don't accept third-party invitations to any events. If you do those things, life will go easy for you. You understand? There's to be regular reporting by Zoom or in person. I'm going to want field visits 1 time per month. Random UAs. When's the last time you used any illegal drugs?
I don't use it.
All right, we're going to do a drug test today. And we're going to do random UAs. Probation, is there anything else she needs?
Your Honor, no.
All right, is there anything else you need from the court in order to be successful? All right, and I'm going to recall the warrant. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you sign it? Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, good luck to you. All right, and so when you do your UA today, what are the results going to be?
Probably will testify for the medication that I have.
All right, just make sure you give probation a list of your medications, okay? All right, thank you. Oh, and probation, see if maybe Mick evaluation will be best for her. All right, thank you. Court is calling 2022 CR 2469, State of Texas versus Stephen Anthony Velasquez. Can I have parties announced for the record for the state?
Ryan Grimmer for the state of Texas.
For the defense?
Barry Hitchings, attorney for the defendant Stephen Anthony Velasquez with a V.
All right.
Junior.
And are you Mr. Velasquez?
Yes, Your Honor.
Defense, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
I have, Your Honor, and I've gone through it with my client.
Court will find that the state is in compliance with discovery. Mr. Velasquez, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Judge.
Mr. Velasquez, I'm showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand your charge of felon in possession of a weapon? The range of punishment for that offense is anywhere from 2 to 10 years in prison and up to a $10,000 fine.
Yes, Your Honor.
If you have a plea bargaining agreement with the state, the court does not have to follow your plea bargaining agreement. If for any reason the court does not follow your plea bargaining agreement, it gives you more than you bargained for. The fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargaining agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea bargaining agreement in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses to this offense?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does, Your
Do you
Honor.
believe he's currently competent, was legally sane at the time of the offense?
I believe he is, Your Honor, and he was at the time of the offense. He was.
Mr. Velasquez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea bargaining agreement to get you to enter this plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial, showing you the plea bargaining page. Did you review that page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea bargaining agreement, punishment is to be assessed at 3 years in the prison. There's a $500 fine. State doesn't oppose the defendant being allowed 30 days to return for sentencing. But as a part of the plea bargaining agreement, defendant agrees he is subject to the full range of punishment if he does not appear for sentencing. Do you understand if you do not appear for sentencing, then your plea will stand, whatever the court's findings will stand. And if you don't show up, your range of punishment will then be anywhere from 2 to 10 years in the prison. Do you understand?
Yes, Your Honor.
Defense, is that the agreement?
It is, Your Honor. His 61-year-old father, Stephen Anthony Velasquez
Oh,
Sr.
we'll get to that point in just a
Okay.
second. Did you understand that to be the agreement?
It is, Your Honor.
State, is that the agreement?
Yes, Judge.
Mr. Velasquez, did you understand that to be the full agreement?
Yes, Your Honor.
Next, I'm showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
There have not been, Your Honor.
Then to the offenses charged in the indictment, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State any evidence to support the defendant's plea?
Yes, Judge. State what offer states exhibit number 1.
No objections, Your Honor.
Mr. Velasquez, I'm showing you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments or review the same.
This case perfectly captures Judge Boyd's courtroom philosophy. She followed the plea agreement: 2 years deferred adjudication, a probated fine, structured conditions, but she made it clear that deferred does not mean relaxed. Employment proof within 30 days. Housing stability within 90. Random drug testing. No contact orders. Theft prevention classes. Every condition is a checkpoint. And behind it all is a simple principle: accountability over excuses. Mental health was acknowledged, but it was not allowed to erase responsibility. Deferred adjudication is an opportunity, not immunity. And if those conditions are violated, the full force of that original state jail felony still stands. If you found this case as intense as we did, make sure to hit that like button. Share your thoughts in the comments, especially whether you think the sentence was fair. And don't forget to subscribe for more jaw-dropping courtroom breakdowns.
All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Mr. Hitchens, so what is the issue with him not being sentenced today?
Well, his 61-year-old father, Stephen Anthony Velasquez Sr., his namesake, has throat cancer. And his father is the U.S. Navy Chief Bozeman, retired veteran. And this allows Mr. Velasquez Jr. to take care of family situations within the next 60 days before his sentencing commences.
All right, you all are asking for 30 days.
I'm sorry, 30 days. 30 days.
All right, so are we going to come back in 30 days and ask for more time?
No. It's 30 days is more than sufficient.
All right. Ms. Ferguson, can I have a 30-day reset for sentencing on Mr. Velasquez? Yes. All right, we'll be back on June 28th.